Welcome back to Mandy. We're about to watch a parole revocation hearing for someone who, violated his parole. He's hired an attorney. We've seen many of these. Sometimes the attorneys, sometimes they blow it for them and sometimes they help them. I have looked up the case that he was initially arrested for, and it's some pretty serious white collar stuff. So we can go over that after the case, and then also want to hear feedback from all of you law enthusiasts, attorneys, about the argument that is made by the attorney in this case. It's quite interesting to me. With that, let's jump in.
The Committee on Parole is called to order. Today is Tuesday, November the 1st, 10:02 a.m. My name is Brennan Kelsey. I'll be chair. Along with me is Ms. Jackson and Mr. Freeman. Staff is seated at DOC headquarters in Baton Rouge. Our remote location is Lafayette Correctional. Is staff or support in that room with you?
Yes, sir. Deputy Joseph.
Thank you. All right, we're ready for our first case. We also have Mr. Cameron Pontiff, who's the attorney. Mr. Pontiff, at the appropriate time, you can make a statement, or if you want to wrap up at the end, we'll go there. All right. Please introduce yourself, state your name and DOC number for the record.
My name is Michael Calvin Duhon, DOC number 741355, sir.
All right, Malcolm, you heard the introduction. Michael, I'm sorry, you heard the introduction. We're here for a parole revocation hearing. I'll read some information to the record. We'll ask for some rule violations. You'll plead guilty, not guilty, guilty with a statement, or not guilty with a statement. We'll ask you some questions. You can respond. At the appropriate time, your attorney can make statements as needed, and then we'll take a vote. Do you understand the process?
Yes, sir.
Do you have a parole revocation questionnaire in front of you or with you?
No, sir.
Okay. Can we put the paper on the screen? There's a parole revocation questionnaire that it says that you refused to sign because your attorney was not there. Do you remember that?
No, sir. I didn't look at it at all because my attorney wasn't present.
Okay, so you refused to sign it though, correct?
No, sir. I didn't refuse to sign. I just said my attorney said that he needs to be present. So I never saw the paper, but I can read it now if you wish.
Can you read and write?
Yes, sir.
And you have your attorney here, and he'll be able to that's enough. He'll be able to have his input and be able to make statements.
Yes, sir.
All right, Michael Calvin Duhon, DOC number 741355. All right, here's your rule violations. Number 3. You moved from your last reported address without obtaining permission from your parole officer before doing so. How do you plead?
Not guilty, sir.
Okay. Number 4, you failed to refrain from criminal conduct as evidenced by your arrest on 9/19/2021 by Lafayette Parish Sheriff's Office for violating protective orders. On 5/25/2022, under docket LAF 182878, you pled guilty to the following counts. 1, violation.
I did not plead guilty.
Okay, let me finish reading and you can plead how you want to plead, okay? This is the information I have. I'm reading to the record.
Yeah, and I want to make sure you understand.
Oh, yeah, right. Let me finish and then you can plead.
Yes, sir.
On 5/25/2022, under docket LAF 182878, you pled guilty to the following. Count 1, violation of protective order. Sentenced to 30 days parish jail with credit for time served. Count 2, criminal mischief, tampering with property, 5 days in jail with credit for time served. Count 3, criminal trespass, 10 days in jail with credit for time served. How do you plead to rule violation number 4? Not guilty. Okay. Okay, well, tell me why you're here.
Yes, sir. I can sum it up in 6 pages if you would just bear with me. I'm gonna.
Well, just you don't have to read it. You know why you're here or not here. Just tell me why.
But I'm kind of nervous, and that's why I wrote it out. So I'd appreciate it if you just give me a minute or two just to read this. The lady that the reason I got arrested was because the alleged victim filed a false public record under LARS 14133. Filing a false public record is the filing or depositing of a record in any public office or with any public official or any deputy required by law that is knowingly false.
Right.
So this is a felony, and she committed 7 felonies, of which was a transfer. Well, let me read the second page.
Mr. Kelsey, may I intervene?
Yeah, please, yes, yeah. Let your attorney is going to intervene here for a minute. Yeah, right. There's your attorney.
So
He's going to speak.
I just,
Michael, Michael, you could speak, but let me kind of sum things up for them and answer their question that they're asking. We'll move forward, okay? Mr. Kelsey, I believe your question was, why is Mr. Duhon here? And that is because he was convicted after a judge trial of violation of a protective order. And we could address that more thoroughly whenever I have a chance to speak, but that is the principal reason as to why we're here, and also for the alleged technical violation that he did not report a change of address.
Right. So, and that's the information that I read to the record. Now you telling me that that's why we're here, but he's saying that that's not why he's here. We're trying to clarify that.
He of course maintains his innocence, and as I will expound when I have the opportunity to, that he was wrongfully convicted in this matter on insufficient evidence. It's clear from the record, from the minutes. I have a letter from Judge David Smith about the TRO and how it was vacated nunc pro tunc, meaning that it was vacated retroactive to the day it was issued, which is September 16th of 2021. And again, as you noted, he was arrested for this TRO, temporary restraining order violation, on September 19th of 2021 to point a protective order in place from this TRO because he was arrested within a week of being released from Louisiana State Penitentiary. I also have a letter from Judge Royal Colbert, the trial judge for the protective order hearing, stating basically the same thing that Judge Smith is stating in his letters, that the TRO and alleged protective order is absolutely null, and any reliance on it was an error. And if I could share my screen at some point, I'd be happy to present those 2 letters to you, as well as the order vacating the TRO nunc pro tunc and the judgment of dismissal signed by David Smith. And then, of course, I could expound as to why it was even signed in the first place. And it wasn't even signed by Judge David Smith. It was by Judge Blanchette, and he did not even read the TRO. He signed it for Judge Smith. So if it was before Judge Smith, initially, it had never been signed to begin with.
I ask a question. In light of that, was there a motion to set aside the convictions?
No, ma'am. I received Mr. Duhon's case file a week and a half ago. That's why I had the first continuance, because I was trying to coordinate with his prior counsel. And I finally received his whole case file, and I reviewed it over the course of the last week and a half. So I have not had the opportunity to try to vacate his prior conviction. And if the board is going to revoke Mr. Duhon simply because he has conviction on paper, I would ask that we continue this so that I may vacate this conviction, because that's really I'm sorry.
How long do you think that process would take?
I can't give a guarantee on how long it will take. I know that I was offered 2 dates, November 1st and December 6th, for his parole revocation hearing. We decided on November 1st because I presumed that I would receive his case file well in advance of that. And considering that Judge Colbert has authored and signed a letter stating that his reliance on the temporary restraining order was in error, I believe that we can get a motion for new trial or a motion to set aside the conviction done exponentially.
Is that how you'd like to proceed?
That is how I would like to proceed if the board intends on revoking him today simply because of the conviction. If not, I would gladly produce the dismissal and the 2 letters if that's going to persuade the.
Share the 2 letters with us right now. Could you share your screen and show us the letters that you read?
I absolutely will. Let's do this. Okay, can y'all see my screen?
I can see it.
Okay, so this is the letter from Judge Colbert. I don't know if you could read it. I'll read it to you. It says, Dear Cameron, the previous protective order and temporary restraining order in the above captioned matter were issued in error, and the judgment was later vacated retroactive to the date it was issued. The protective order and TRO are/were absolutely null, and any reliance on the same is/was in error. And that's from the trial judge, Judge Colbert. And then if we look at Judge Smith's letter, it states essentially the same exact thing. He was the judge who vacated the order nunc pro tunc, and I will show you that order if you would like. It says, Mr. Pontiff, previous protective order and TRO in the above captioned matter were issued in error, and the judgment was vacated retroactive to the date it was issued. The protective order and TRO are absolutely null, and any reliance on the same is/was in error. And that is signed by Judge David Smith. So this is part of Mr. Duhon's extensive case file. And let's see. So here's the judgment of dismissal signed by Judge Smith. It says the reason for the dismissal is insufficient allegations did not meet burden of proof. And that's from the 9/16 date. And that was signed on March 28th of 2022. And here is the order vacating that temporary restraining order, nunc pro tunc. So essentially, it was an absolutely null temporary restraining order, and it has no legal effect. It has been absolutely null since it was signed. So at the time of his trial in May, that evidence was presented. It's in the minutes, and it was just relied upon in error.
All right, thank you for sharing that with us.
Absolutely.
Can I ask for an executive session?
Sure. Yeah, we have a second. Have a motion for executive session. We have a second. Roll call, please. Yes.
Keith Freeman, everybody, we got to vote for. Okay, second.
We have a second. Roll call. And I said yes.
Yes. Yeah.
All right, we'll be right back. We're running executive session. Thank you.
All right, thank you.
Man, talk about attorney to the rescue. I don't know why his client Michael didn't just let him start. It was, you hire an attorney like that for a reason. He's come prepared, he's come ready, and he has come armed with information. Do you think that the board is going to let him go back home? And then we do have, are they back already? Yes, they are. Okay.
All right, we're back. All right, Mr. Potter, thank you. Thank you for that information. Appreciate you the information. Mr. Duhon, we've been discussing with your attorney. Obviously, you've been listening. Would you like to make a statement before we vote? It would probably be wise just to say no.
Yeah, Mike.
Okay.
Mike, I think you're fine, Mike.
Okay. Panel prepared to vote. I'll vote to do not revoke your parole, to return you to your normal supervision status based on the information we have provided to us from Mr. Cameron Potter. Ms. Jackson?
I likewise agree. My vote is to do not revoke and return to supervision, but you also need to provide your parole officer with a valid current address for supervision.
Okay, Mr. Freeman?
I concur with my colleagues. I vote to do not revoke. Make sure you show up to your probation office when they let you out. You don't have it.
Yes, sir.
All right, 3 votes do not revoke, return of supervision. Good luck to you.
Thank you, sir.
Thank you, Mr. Pontiff.
Absolutely. Thank you all so much.
Thank you.
And we'll adjourn at 10:16 at Lafayette.
Well, sometimes it pays to pay. I think those are certainly one of the times. Anyone who has experience and kind of really knows what just happened, if you could put it in the comment section, because I mean it's not entirely clear to me. Like, what was this? Was this someone understanding the law and getting out of trouble for violating, or did they, or was there actual like mistakes made in revoking his parole and he just sat in jail for no reason?
They let you out. You don't have it.
That's what is just not clear to me. Like, I don't know if it's someone who understood how to work the system, or if it's or if they totally screwed up. So yes, but it something interesting about this the crime that he was initially arrested for. Also, it's showing a pattern of him seemingly to be quite intelligent, and it looks like he's won appeals too on even the convictions that he was initially arrested for. Also, when I look him up on Google, I don't find anything, which either this was completely a non-news story, so it didn't make the news, or he's hired people to move any of the reporting to the further down Google search. But it seems that he was found guilty of wire fraud, money laundering, and then taking advantage of the infirm. So he stole money, more than $400,000 in land and retirement funds from the victim, Mary Dutch. The defendant's theft involved complex financial schemes whereby he moved the money through shell corporations and different bank accounts to conceal the fund's source. As a result, the defendant was charged by bill of information with 1 count of theft over $25,000, which is interesting. It's like, if you steal more than $400,000, you're saying it's the same thing as if you sold $26,000? Like, is that just how the law works? They don't care if you steal more than $25,000 if it's $1 million? In violation, 1 count of money laundering and 1 count of exploiting the infirm. So he was, and he took a jury trial. The defendant was acquitted of the charge of exploiting the infirm, but guilty regarding the remaining 2 offenses. So I wonder if they're just saying that they didn't want to consider her infirm. I don't know. And he ended up getting off on basically, like, so he got an initial sentence of, so the sentence is 15 years of hard labor, if you can imagine getting 15 years. And all but 11 years of the sentence was suspended. And on the count of money laundering is also 15 years, with 11 years of that being suspended, but they're run to concurrence. So he has an 11 years, and then, but I don't think he actually served any time. Also want to make sure it's clear for the record that the terms of probation will be 3 years for the suspended part of the sentence, and probation on each sentence will run concurrent. And also the probation will run concurrent with parole, because Mr. Duhon will parole, and I want his probation to begin once it begins parole. The conditions of probation, as I had previously stated, are all the normal conditions, which include reporting, free of criminal activity, owning, possession of fire, also requiring defendant will remain injured. 60 hours community service, half through litter abatement, and the restitution in the amount of $331,500, which is part of the sentence in this case. But I do note that $331,500 in restitution is part of the sentence. It is non-dischargeable debt because it's based on defalcation. I also note that another provision acting like the capacity investment advisor, blah, 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 blah. I don't think he actually served any time. I'm trying to find the information, but I think it was where he... I think it was time served. And then it was just that probation period. So I'll include these links. There's a couple of them in the description, but he seemed to have kind of keep getting off from whatever it is that he did in some sense, not completely off, but yes, again, love to hear someone who understands all of these details and can share it in the comment section. And with that, I will let you go.